Isn't this a case where the defense has to get up and say, yeah, she killed her, but, and come up with something?
I think so, and and I think if you got to find wiggle room, much ado has been made of the statement that was overheard by a bystander, but there really is no evidence that's been produced yet that the statement actually came from Miss Boat. So, if you're looking for some wiggle room, I think one could argue reasonably that the victim made that statement. It would fit. They both claim some ownership to this gentleman, and you could make the argument that it was someone else that made that statement, unless the bystander is going to say she was familiar with the perpetrator in this crime and knew her voice inside and out. I think you can make that statement credibly, and that would take away at least this piece of communication that they seem to suggest goes to the issue of intent.
Yeah. And we don't think that that is the case, and just from the limited information we have from the complaint. There was a trail of incidents leading up to the murder. Now, the jury won't hear any of it, but she was convicted of, or not convicted, but she pled not guilty in March of 2020 for violating a no contact order. She was released from custody there. Then in April 6th, just 7 days later, boom, back again, pled not guilty, no contact. This time she has to post bond. April 16th, she's allegedly threatening a nephew and saying she's going to stab this nephew. She pleads not guilty there. Then May 18th, accused of violating the no contact order the same day as the alleged murder. This obviously is a woman that was going off the rails and has that, but the jury in this case isn't going to see that information, correct?
I don't know, Ted. I think in regards to the incident with the nephew and the knife, although it does involve a knife, I don't believe there's anything substantially similar that would allow one to get around the prohibition rules associated with that kind of evidence. But, in regards to some of the things that you've outlined leading up to the day of the incident, including the day of the incident, depending on what sort of defense is posed, some of this stuff could arguably become admissible. If the defense is going to argue, again, that when approached, the victim made the statement and maybe pulled out a knife and there was some kind of struggle, that it was self-defense in effect, then the prosecution would, I believe, be able to introduce this previous conduct to show that she was someone that was prone to violence, ultimately leading into a protective order. So there are windows that it could come in potentially, depending on how the defense chooses to proceed.
And that's